everyone, and welcome to another episode of the Interlink podcast, an initiative under the Center for New Economic Studies at the Global University. Interlink aims to hold nuanced conversations on the interdisciplinary nature of problems plaguing the world today. As we engage with the evolving socio-political climate, our goal is to break down the intellectual silos and explore issues through a multifaceted lens. In this episode, we delve into the global response to mass atrocities through the lens of international law, examining the legal framework of genocide and the evolving role of international tribunals and the International Criminal Court, and the politics of accountability. We are honored to be joined by Dr. Juan Vallejo, Assistant Professor and Assistant Dean for International Internships at the Jindal Global Law School, OP Jindal Global University. Dr. Vallejo research spans across public international law, international criminal court, international humanitarian law, and international human rights, placing him at the forefront of legal scholarship on the issues of global justice and accountability. Thank you so much, Dr. Vallejo, for taking the time to join us today. It's a pleasure to have you here with us.
Thanks for inviting me, Gitali.
All right, so we'll move on with our first question. Professor, how has the legal definition of genocide shaped which atrocities are prosecuted and which are overlooked?
Yes, in order to understand what is a genocide, of course, we have to look at the legal definition of the crime. It's the Genocide Convention, the treaty that was enacted in 1948, the treaty that established and contemplates the crime of genocide. Of the Genocide Convention reads that genocide is an act committed to with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. More specifically, the Genocide Convention, this Article 2 of the Genocide Convention, lists 5 acts. This is an exhaustive list. Killing members of the group, causing serious bodily or mental harm to members of the group, inflicting conditions of life calculated to bring the physical destruction of the group, imposing measures intended to prevent births within the group, or forcibly transferring children from one group to another group. If any of these 5 acts are committed, of course, with the intent to destroy in whole or in part the specific group, which is, the element of or the specific component of dolus specialis, then we can be talking about the genocide. That's the crime that is going to be prosecuted according to the Genocide Convention. Genocide, or the crime of genocide, again, it's a crime of international law. Maybe the most serious crime. It is the most serious crime in the area of international law, according to different scholars. According to William Chavas, for example, this is the crime of crimes. It means that it's the most serious crime. Right? It's also a customary obligation. It means that it's prohibited under customary international law to commit a genocide, and it's also a jus cogens norm. It means that it doesn't matter if a specific country or if a specific state has not ratified the Genocide Convention. That country cannot excuse itself, and that country cannot commit a genocide, alleging that it has not ratified the Genocide Convention. We're talking about a customary norm. We're talking about a customary obligation, and that's why the crime of genocide cannot be committed. So, that's the legal definition. That's the crime that is going to be prosecuted as such. Now, if we talk about jurisdiction, that's a different issue. If we talk about enforceability, or if we talk about accountability and the prosecution of the crime, that's a different question. The crime as such can be prosecuted by a domestic court or by an international court. At least that's what the Rome Statute establishes. Domestic courts as such have the competence to prosecute the crime of genocide when this crime has occurred within the territory of the state. If that's not possible, according to the Rome Statute, then it's going to be an international tribunal. It could be the International Criminal Court or any other international tribunal, the one that prosecutes the crime of genocide. So, legally speaking, those are the this is the way how this crime is prosecuted. If we talk about enforcement, we're going to see, and it's common to see how this crime has been prosecuted differently in different states. If we talk about enforceability, for example, we have the case of Guatemala. In Guatemala in the 80s, a genocide occurred there. And at first, one of the main perpetrators, the former president of Guatemala, Rios Montt, was condemned back in 2013. But later on, the Constitutional Court of that country reversed this sentence. And we have another case. We have the current situation that is taking place in Palestine. There, according to different human rights organizations, according to the latest report of Francesca Albanese, they think that this is a genocide. Why this crime or why these events have not been prosecuted? We are talking about a different situation there. We are talking about political issues. It's important to remember that all these judicial prosecutions have political implications as well. And that's why maybe these, you're going to see that some situations are going to be considered more than others, which is also a problem of international law as well, that we can analyze later on.
So, in a way, we can say that the legal threshold is high, and that can make the definition both politically convenient and morally frustrating. Delving on to that, have tribunals like ICTY, ICTR, and ICC delivered meaningful justice or mainly symbolic outcomes?
Mm, you know, uh, Meaningful and symbolic, both are equally important. When we talk about justice, we have to remember that justice is not just about convictions. It's not just about convicting perpetrators and convicting people. The more people we convict, the better. It's not like that. Justice is also about truth, about reconciliation. Justice, it's also about redressal. Justice, it's also about peace, about restoration. But of course, having said that, it is much better to have more perpetrators being convicted than not having them at all. And to give you an example, I can refer to the case of the Cambodian genocide. The hybrid tribunal that was established to prosecute the crime of genocide, in the end of the Cambodian genocide, convicted only one person. Just one person was convicted for committing the crime of genocide. But even if we talk about one conviction, that conviction alone is sometimes more than enough to deliver a message, because here we're talking about delivering a specific message, the message that international law and international criminal law more specifically delivers is that committing a genocide is not okay. And that's important. That's important. Even one conviction is important. Here we can say it's a symbolic conviction. We don't have 10, 20 convictions. We have just one conviction. But it's important because we are having the judicial recognition of the genocide, which is very important. Another example could be the case of the genocide that was committed against the Kurds in Iraq. In this case also, or in this situation also, we had only one conviction on genocide charges. this criminal, also known as Chemical Ali, he was the only one who was convicted on genocide charges. Remember that this genocide occurred when Mr. Saddam Hussein was the president of Iraq. And even when we have just one conviction, and we can say, yeah, it's just one conviction, it's a symbolic conviction, we don't have too many convictions, but that conviction alone in Iraq was important because it delivered a strong message, the message that a genocide had taken place, that that genocide was not okay, and more importantly, that these acts, that these genocidal acts should not happen again in the future. So that's why I say that symbolic convictions are also important. But of course, if we talk about numbers, we have had some international tribunals. Maybe the most important today is the International Criminal Court. So far, we don't have a single conviction on genocide charges. But we talk about the International Criminal Court, but there are some open situations. The first one could be Darfur, Sudan, and there is another situation in regards to the genocide that was committed against the Rohingyas. In this case, there is an open situation to analyze, which is actively studying the situation that took place in Myanmar, because many of these Rohingyas reached Bangladesh. Remember that Bangladesh is a signatory country of the Rome Statute. So there are some open situations, but specifically, if we talk about convictions, the International Criminal Court has not delivered a single conviction on genocide charges yet. If we talk about these other, these other tribunals such as the ICTY or the ICTR, the International Criminal Tribunal for Yugoslavia, and the International Criminal Tribunal for Rwanda, of course, we have many convictions, some of them convictions on genocide charges, some other convictions on other charges. Remember that when we talk about international criminal law, we are also talking about the possibility to prosecute other crimes against humanity and war crimes as well. So that's just to give you kind of the whole spectrum of all this.
Yes, Professor. I mean, many victims still live with the trauma, and prosecution, if they happen at all, occur years after the violence. And so we can say that while these tribunals have advanced the idea of accountability, the reality is that justice has often been delayed, partial, and uneven. So, on that note, how does international law shape collective memory after atrocity?
Good. Uh, Collective memory is important. It's important, and if you allow me, the more or less the definition that I have of what is a collective memory, and why it's important to consider how international law shape this collective memory, as you say. It's important to remember what happened. It's important to remember what happened, mostly when we are talking about gruesome and terrible acts. And it's important to remember what happened because we need, as human beings, to understand the present. And it's important also to remember what happened because we need to look at the future. And if we talk about international criminal law, we try to avoid the repetition of these gruesome acts. That's why collective memory is important, to remember what happened, to understand the present, and to look at the future to avoid repeating such gruesome, terrible acts. That's collective memory. Okay. Now, the role of international law, not only international criminal law, but international law as a whole, and all the institutions that we have, create awareness, and they these institutions educate people. If we talk about international justice delivers a very specific message. The message that something happened, that something that happened is something bad, and that something that happened, which is bad, must not happen again, right? So that's the message that the international criminal law delivers. Now, that message sometimes is well received. Sometimes the message is rejected or is contested, and sometimes we have kind of a mix. Right? So a great example of how the message that international criminal law delivers is well received could be the case of Germany. Germany after the Second World War, thanks to the Nuremberg trials, the German people understood that committing a genocide is not okay. The German nation understood that the Holocaust was not okay. And because of the Nuremberg trials, there was kind of a sense of shame. They committed these horrible crimes, these atrocities, and they said, this is not okay. We should not do this again. And that's why in Germany, for example, disseminating Nazi propaganda today is a crime. Right? And denying the occurrence of the Holocaust also in Germany is also a crime. Right? So that's a great example of how this message, the message that international criminal law delivers, is well received. Sometimes that message is not well received, or it's not received as we should expect. And that's the case, for example, of Srebrenica. Remember in Srebrenica also a genocide took place in the 90s during the Balkan conflict. And what happens in Srebrenica today, for example, is that in Srebrenica today, what is Republika Srpska, the Serb entity in Bosnia, they have continued to deny that the genocide occurred. So even when we have some genocide convictions because of the genocide that took place in Srebrenica, this message, it seems that it has not been well received. Sometimes this message is contested. And that's why I say it depends how the community as a whole and the nation and the society receives this specific message. And sometimes the reception of this message, it's a mix. And we can take the example of Rwanda, for example. In Rwanda, around more than 30 years ago, in 1994, a genocide took place as well. And even when, Rwanda sometimes is considered as a great example of how the message of international criminal law has been received in a good manner. There are some issues that, for example, talking about genocide or talking about Hutus and Tutsis in Rwanda could be controversial today. That's why I say, the case of Rwanda, it's kind of a mix, right? So it depends. It's going to depend. All genocides are not the same, and every situation is different. But again, the message that international law and international criminal law more specifically delivers is very important. The message that committing a genocide is not okay, and that genocide should not take place again. It's important.
So, delving deeper into this discussion, of course, we can argue that power is deeply embedded in the global justice system. So, on that note, how do these power asymmetries influence who is held accountable and who is shielded?
It's a good question. As a rule, uh, I think there are two important principles of international law. The first one is the principle not only of international criminal law, but of international law as a whole. The first one is the principle of universality. It means that international law applies to everyone. International law and international human rights law as well protects everyone, no matter who you are. And the second important principle, and this is more a principle of international criminal law, is that no one is above the law, right? So it doesn't matter if you are the most powerful person, it doesn't matter if you are the prime minister or the president of your country, you are still accountable. If you commit a serious crime, if you commit a crime against humanity, if you commit a war crime, or if you commit a genocide, you're still going to be held accountable, even if you are the most powerful person in your country or in the world. Having said this, we have to remember, and it's something that we must keep in mind, politics play a big role. Right? Politics shape the system that we have, the international system that we have, the United Nations that we have, the International Criminal Court that we have, the International Court of Justice that we have. All these institutions that we have them because there was some political commitment to create these institutions, right? So it's important that, to remember that these institutions were created because there was, at some point, the political willingness to create these institutions. But the proceedings and the proceedings of these institutions also, they have political implications and they have political consequences as well. So we're talking also about political interests. And when we talk about political interests, we're talking about power disputes as well. So more or less, it goes to the, it's related to your first question, I guess. Sadly, it's a question of politics. We all know that double standards are bad. We all know that exceptionalism is bad. It's not okay to say, international law applies just to a few countries, but to other countries, these international norms do not apply. Again, this goes against the principle that no one is above the law and against the principle of universality of these international human rights norms. Some journalists, some scholars as well, talk about the incoherence of the international system that we have. Some others prefer to talk about the hypocrisy of mostly the powerful actors. When we talk about the powerful actors, we have to remember and we have to look at mostly at the members of the UN Security Council, the big five. It's always kind of the question that people ask: why is that everyone or most of the countries have signed the Rome Statute, but there are a few countries that have not signed, a few countries that have not ratified the Rome Statute, which is the treaty that gives jurisdiction to the International Criminal Court. Surprisingly, or not surprisingly, we're talking precisely about these permanent members of the UN Security Council, who usually are the ones who are being accused of not complying with these international norms. So that's important. It's important to keep in mind that as you mentioned, there are some power asymmetries, and but it's important also to try to look for the mechanisms to solve this problem.
So we can say in a way that these asymmetries aren't just structural, they are political, and that international justice is mediated through institutions that depend on state cooperation, funding, and enforcement. So this dependency is what makes justice vulnerable to selective application, which is ultimately undermining the legitimacy. So on that note, what holds the pillars of our country, what maintains order is law, which can be both a tool for healing and a source of frustration. So on that note, can law meaningfully contribute to healing, or does it does it reduce trauma to procedure?
Okay, this is a good question. I think it depends. If by law you mean uh, international criminal law, if by law you mean justice, my answer is going to be affirmative. I prefer to think positively. Uh, but again, uh, I think as a lawyer, I'm a lawyer, and I'm aware also of the limitations that my opinion may have. And I mention this because psychiatrists, some victimologists have addressed this issue in a better way, more than lawyers. Right? If you ask me, I prefer to answer in the affirmative. I think that yes, international criminal law contributes to healing. It helps reduce trauma, and it helps victims find peace. That's why we have these institutions, that we created these institutions, and that's why personally I still have a faith in these institutions, in international criminal law as such.
So the question was, how might accountability frameworks evolve to address emerging or historically omitted forms of mass violence?
Uh, okay, so if by accountability frameworks you mean international law and international criminal law more specifically, of course, international law and international criminal law can always evolve and can always be improved. When we talk about international criminal law, we are talking about a system of laws and institutions and norms that are not perfect per se. Is the system that we have is not perfect, and that's why it can evolve. It can be improved. How? Just a few ideas come to my mind. One of these ways how international criminal law can be improved could be, for example, by incorporating new crimes. Right? We can create new crimes. Either there are some proposals, for example, of creating the crime of ethnic cleansing, which is not the same as genocide. Uh, there are some proposals of creating the crime of terrorism, right? Which again, there are some domestic legislations that have the crime of terrorism, but at the international level, we don't have an international crime of terrorism as such. We can also improve this international criminal system that we have by prosecuting some of the crimes that we already have, but they have not been prosecuted, at least not in the same way as how some other international crimes have been prosecuted. I'm talking specifically about the crime of apartheid and also about the crime of aggression. The crime of aggression, importantly, it's one of the crimes that the Rome Statute also has, and it's relevant to consider the crime of aggression in light of the recent events. We have at least 4 or 5 international conflicts. The international community that aggression is a crime, right? And it should have to be prosecuted as well. We can also improve the international system of criminal law that we have by reinforcing the mechanisms that we have to prosecute these international crimes, to prosecute the crimes that we already have, the crimes against humanity, to prosecute war crimes, and to prosecute the crime of genocide as well. I already said in the previous question that you asked me that one of the or two of the main problems that international criminal law faces today are the problems of the first one, the problem of exceptionalism, the idea that international criminal law apply just to some states, to some people, to some actors, but not to everyone. That's not okay. It's not okay because it creates this sense of that not all of us are playing by the same rules. Uh, and the problem is the problem of universality. We know that international norms, mostly these international human rights norms, are universal. They apply to everyone, no matter their nationality, no matter their race, their origin, their religion. But of course, today you know that it seems that some people and some states are more protected, at least more than others. It seems, or at least there is this idea that some people deserve better rights or more rights than others, and that's not okay. Again, international law and international norms apply to everyone, and no one is above the law, right? So, considering these problems, we must look for ways to improve international criminal law, right? And I think that way I answer your question.
All right. So that brings us to the end of this deeply insightful episode of the Interlink podcast. Dr. Valhejo, thank you so much for taking the time to join us today and for sharing your expertise on such complex and urgent issues considering our contemporary times. Your reflections on the evolving role of international law in addressing mass atrocity, justice, and memory has kind of given us a nuanced lens through which we can understand the limitations and plausibility of global legal frameworks. And we're incredibly grateful for your thoughtful engagement. And we hope that this conversation encourages our listeners to think more critically about how accountability and justice is reimagined in the world, which is grappling with such historic and ongoing violence as we can see in other countries as well. So, thank you again. And it was great having this discussion with you.
My pleasure. Thank you very much for inviting me, Kitali.
All right. So, have a nice day, Professor. It was great meeting you.
Thank you.
Goodbye.
Bye bye.